So a huge ruling dismissing a machine gun possession charge, and it dismissed that using the Second Amendment, finding that these restrictions are unconstitutional. That is now being appealed and is being reviewed by the 10th Circuit Court of Appeals. So this is huge news that we need to talk about. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Brownells. A lot of you guys know Brownells. They have an amazing website. A lot of people buy products from them. They always have amazing deals. They're also just great people. I got to spend a lot of time with them out in Iowa. Again, pro Second Amendment people. They believe in what we're doing here on the channel. So if you're interested, head over to their website. I can't link it here, but if you use the code SCHOLAR10, you can get 10% off of your order. Now, as I mentioned in the intro, in this video, we're going to be talking about a very interesting case and a huge decision that was issued recently by a federal district court, essentially dismissing a machine gun possession charge of an individual, and the judge did that using the Second Amendment. So they found these restrictions on machine gun possession was in fact unconstitutional, that the government did not provide enough evidence under the Bruen analysis that was issued by the Supreme Court, and because of that, the judge there dismissed the machine gun charges. The case we're going to be discussing in this video is called USA versus Morgan, and this was a decision issued by a Kansas district court judge, so a federal judge, and his name was John Brooms. So this federal district court judge here reviewed this issue, reviewed the issue of these machine gun possession charges under the GCA, a claimed violation of the GCA in possessing these types of firearms, and the judge here found that the government, the United States, did not provide enough evidence to back this argument and did not provide enough support to actually say that the Second Amendment here is not violated by these restrictions. Now, that decision was huge because it was one of the first times that we saw a machine gun possession charge actually dismissed by a federal court because the court there found that the Second Amendment actually stopped these types of restrictions. And now the federal government here, the United States, has appealed that ruling up to the 10th Circuit Court of Appeals. So now you have a federal circuit court, the 10th Circuit, which is going to be reviewing this issue and that decision, which again is huge. Now, the facts surrounding this case are as follows. The defendant here, Tamori Morgan, is charged with 2 counts of possessing a machine gun in violation of the federal law 18 U.S.C. section 922-0. Specifically, he as the defendant is charged with possessing various firearms that are machine guns, various, Anderson manufacturing machine guns, and then also some Glock switches, which were also in his possession. So he is charged under multiple aspects of the federal law for possessing various items that are believed to be machine guns. Now, the analysis of the court here essentially says that the defendant argues that 18 U.S.C. section 922-0 is unconstitutionally facially and as applied to him. So here you have the defendant, Mr. Morgan, who is bringing both a facial challenge and an as applied challenge. Now, a facial challenge is that he is generally challenging the constitutionality of the federal statute at large, saying that on its face, it's unconstitutional, that it violates the Second Amendment. And then as applied to him, specifically as applied to his specific situation, it is also unconstitutional. The decision of the court says that defendant first argues that under the first step of the Bruen analysis, the plain text of the Second Amendment applies to his conduct of possessing machine guns. The government argues to the contrary, pointing to the language in Heller that suggests the unconstitutionality of machine gun regulation would be startling, and the Second Amendment only applies to weapons that were commonly used by law-abiding citizens at the time of the Second Amendment's enactment. Here, plaintiff is charged with 2 counts of machine gun possession, and both counts apply to arms that can be carried in the hand. Thus, by the definition, the machine gun and Glock switch are bearable arms within the plain text of the Second Amendment. Again, a very critical finding here of a federal court saying that these are arms protected by the text of the Second Amendment. The court then went on to look at 2 critical Supreme Court cases, the Heller case and then also the McDonald case. Now, in the Heller side, they said that the government relies on Heller to argue that machine guns are not covered by the plain text of the amendment. The Heller language cited by the government is unavailing. First, the government's interpretation of Heller relies exclusively on dicta, and the circuit authority that predates the historical analysis mandated in Bruen, machine guns were not at issue in Heller. Second, the government's interpretation would run directly counter to the essential analysis in Heller. Just as the Fourth Amendment applies to modern searches, the Second Amendment applies to arms that did not exist at the country's founding. So there you have the federal court outright rejecting this argument that the federal government is making. For some reason, the federal government walked out the argument once again that these types of machine guns did not exist at the time of the founding. Therefore, they're not arms protected by the text of the Second Amendment. And it was very easy for the federal court here to say that's a horrible argument. We have language in Bruen and other Supreme Court precedent that says no, the only types of arms protected are not just muskets, it's even, new firearms, it's even things like machine guns. These are bearable arms. They can, be held, and therefore they're protected. The court then went on to look at Miller, and under Miller, they said that third, interestingly, over half of the opinion in Miller was devoted to explaining how in the years preceding and immediately following the enactment of the Second Amendment, one of the lawful purposes for which law-abiding citizens possessed modern firearms was for service in the militia. The court surveyed several laws from that era that not only permitted but also essentially required law-abiding citizens to provide for their own use of modern military-style small arms. Against that backdrop, the court concluded that a sawed-off shotgun was not the type of weapon that would be useful for military service. And then they go on to say, since these are clearly arms and this is conduct protected by the Second Amendment, the burden then shifts to the federal government to justify these restrictions. And the government here, the federal government, only put forward two analogs, two pieces of history to justify this restriction and the machine gun possession charges. And the court here found that those two analogs did not meet the government's burden. They stated, to summarize, in this case, the government has not met its burden under Bruen and Rahimi to demonstrate through historical analogs that regulation of the weapons at issue in this case are consistent with the nation's history of firearms regulation. Indeed, the government has barely tried to meet that burden, and the Supreme Court has indicated that the Bruen analysis is not merely a suggestion. Now, that's also important to note because here you have the court saying, I am following Bruen, I'm following the historical analysis, the Second Amendment analysis outlined by the Supreme Court. The burden was on the government to try and justify this. Maybe if they would have put forward more history and evidence, if they could find some, maybe the court would have ruled in favor of the federal government. But here the federal government just said, well, this is machine guns, so we're not really going to do any work. We're going to be lazy. And the federal court here said, nope. If we're going to follow the analysis under Bruen, if we're going to follow the text of the Second Amendment, you lose this and we're going to dismiss this machine gun charge. Now, as a result of that decision, now the federal government has decided to appeal that ruling, that dismissal, up to the 10th Circuit Court of Appeals. And they appealed that on October 2nd. Now, as of right now, the 10th Circuit has set the briefs to be due on November 12th, 2024. And then here in response to that, there is a response brief that can be filed 30 days after that. And then there's going to potentially be a reply brief 21 days after that as well. So this will start moving here very soon. The first briefs are going to be due on November 12th. So you'll have the first arguments made by the federal government on why they should have won at the lower court level, why the court here, the lower court, got this analysis wrong, maybe why there is historical support to justify these types of machine gun restrictions, why this doesn't violate the Second Amendment. So this is going to be very interesting. You're going to have a federal appeal in the 10th Circuit reviewing these issues of the machine gun possession charge and whether or not it violates the Second Amendment under Bruen, Rahimi, and the text of the Second Amendment. So again, a huge case now up in the 10th Circuit for review. And as we get more information, as things develop, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.